Mr. Krishna. I'm not minded as to who starts first. I thank you very much for the documents that you sent across, including the e-bundle and the list of issues. I've read through the respective skeletons, so thank you very much for providing those. I've got some preliminary thoughts that I'm very happy to share with you from the outset, but if you prefer to go ahead with your submissions first, we can get started with that, and then we can progress to directions. So I'm completely in your hands as to how you wish to proceed.
As I am in yours, if you have some preliminary observations, I think it's only appropriate that you raise them, and then we can take things forward from there. All I would say is, as this directions hearing has been scheduled following our letter to you dated the 14th of November, it's probably appropriate that we make our submissions first, as we have sought directions.
Okay, so Mr. Krishna, you're saying that you'd prefer to start with the submissions and then
No. So, I apologize. I said if we start with your preliminary observations, then in terms of the order in which the parties or the parties council address you, I was saying that we have sought direction. So in terms of as between me and Ms. Burt, it's probably better for me to go first.
Okay, Ms. Burt, would you provide your comments?
Thank you. We agree. Certainly most efficient if we could proceed with your directions, Registrar, and then we also agree, since this directions hearing has been called by the Claimants Council, we are waiting to hear from the Claimants Council first once they make submissions.
Fantastic. Okay, well, I'm hoping, so Mr. Krishna, has the matter now been assigned to Nimble, or has it been given to, or is it still with Ben Eid? Are you acting as co-counsel?
My firm has been brought on as co-counsel. No, as far as I'm aware, no decisions have been made about a complete change of legal representatives. For the purposes of this hearing, of course, I've been brought on as the Part 2 advocate.
Okay, very good. Well, I'm really hoping that your firm being appointed, or at least you being appointed, Mr. Krishna, as a prominent Part 2 practitioner, that the way the procedural timetable pans out from here on in will be very strictly adhered to. Because I think that at this stage, in terms of my comments, I've got some very strong concerns about the conduct of the solicitors acting for the claimant. I think that there's been an order produced by Justice Giles and it hasn't been complied with. And it looks like the defendants are now trying their hardest and their utmost to get you to comply with it. And they shouldn't have to resort to the measures that they're resorting to. They shouldn't have to file the application that they've just filed, again, seeking the claimants, compelling them to comply with the orders. So I think there's lots of things at hand. I think that certainly the defendants are treading on the territory rather unaggressively, and they are now at a stage where they could be pressing for unless orders, commercial orders, immediate judgments, and the like, and most certainly code of conduct complaints against the practitioners previously acting for the claimants. I'm not going to get into that because I'm not going to put words or thoughts into the defendants' minds, but I think that they have very graciously approached the matter with respect to document production, and I think it's quite simple. I think the claimants are saying that if they are compelled to comply with certain orders, they will comply. But I think that obviously I've seen the issues in respect of the native and original forms of correspondence. I've seen the submissions that you have made in that regard, and I agree to an extent with submissions provided to date. However, there's been a lot of other types of documents that would have had to be produced at earlier stages of the proceedings, and these have not been produced yet. And I'd like to understand why, given that an order has already been issued by Justice Giles on the same. And now what it looks like we're facing is a further application for better production of documents. And I've never in my life seen a second application asking people to please comply with a court's order. It's completely unreasonable to expect someone to file a second application requiring the other side to comply with a court order. And like I said, at this stage, what I would have seen from more aggressive litigators is perhaps an unless order or a commissional order for failure to comply. So these are my thoughts at the moment. I hope that we can come to some arrangement at the end, and perhaps the parties can agree by consent certain aspects of the orders that are about to arise. But I'll hear your submissions, and in case the parties cannot come to any agreement, then I will obviously have to produce my own order, which I hope will be very much complied with immediately. So over to you, Mr. Krishna. I understand that Ms. Burt wanted you to start us off. So let's hear from you, and then we'll go along to Ms. Burt's submissions. Thank you.
Thank you, Madam Registrar. At the outset, I mean, I appreciate that Mr. Justice Giles had made some observations in his document production order concerning the blurring of lines, but as he called it, between robust advocacy and unwarranted assertions. And yeah, it's not my place as someone who's come late to the party to apologize for any previous lapses, but I take your point, and I can assure you that going forward, any correspondence will be within the bounds of the code of conduct and accepted practice in this court. This directions hearing has been scheduled, as I said, following our letter to you dated 14th of November in connection with the defendant's application of 9th November, seeking an order compelling the claimants to comply with the document production order. You have before you a small document bundle produced through case lines due to some technical issues which we've raised in correspondence. It's not in the most pristine form, for which I apologize, but it has 4 sections, R, S, T, and U from the master bundle. Section R is the case management order. Section S is the document production order. Section T is the application itself. And Section U contains the skeleton arguments, correspondence, and a couple of cases which we've referred to in our skeleton argument. It also contains a list of the unagreed issues which you've seen. I should begin by saying that the claimants are not asking for the application to be decided at this hearing. We're not asking you to dismiss the application. We're seeking directions as to the appropriate way forward in relation to the application in a way that will minimize the disruption to the procedural timetable. When this court is faced with any application, the application is capable of being dealt with in one of 3 forms. The simplest one is through correspondence pursuant to RDC 2377. In the middle, you have applications that are dealt with on paper, which would nonetheless require evidence from both sides. And the most cumbersome and disruptive is an oral hearing. We have sought to engage the defendant's solicitors in correspondence aimed at a more reasonable and efficient path forward, but they insist on evidence being served in response to the application and for the application to be heard orally. This puts the claimants at a procedural disadvantage, which is why we're before you today. This application being one to compel compliance with the document production order, the starting point needs to be for the evidence in support to deal with the applicable test for such compliance. The witness statement provided in support of the application does no such thing. It also contains a representation that WhatsApp and Gmail communications can and should reasonably be provided in native or original forms. If the claimants are to proceed to provide evidence in response, they would effectively need to discharge the defendant's burden of proof on these points. It's for this reason, as well as to minimize the impact on the procedural timetable, that we've asked the defendant's solicitors to tell us, does the defendant allege that the document production statements do not comply with the law? Is it alleged that the document production statements are false or were made without an honest belief in their truth? And in respect of these so-called native or original forms of WhatsApp and Gmail communications, what are they? And what is the basis on which you say it's reasonable to produce those communications in these so-called native or original forms rather than in the searchable electronic forms in which they've been produced? And the response has been that these are simply issues that we would like them to address, and that we should just proceed to provide evidence in response to the application. So where we're at is we're trying to engage the defendant's solicitors in correspondence to say, please provide this. So which these answers are required in order for us to deal with the issues in evidence. So and given that there's a disagreement between the parties on the format in which the documents are to be produced or have been produced, that would require a direction, require a referral for directions from a judge pursuant to RDC 2814. Otherwise, we'll remain open to criticism that we're not complying. So if you have to provide evidence in response to the application, we deserve clarity on our obligations. So, and that's why we are here before you. Now, the allegations made are serious, and we wrote to you saying these are serious allegations. We asked the defendant solicitors for time to investigate these allegations and respond to them. We have indeed investigated the allegations and have provided a response. And as I just mentioned, we have identified inadequacies in the application, which put us at an unfair procedural disadvantage, because what you have is documents that have been produced and document production statements verifying compliance with the document production order. If we now have to deal with an application to compel compliance, the starting point is the document production statements themselves. It's an unfair reversal of the burden of proof to say, we'll deal with the documents that you produced and say that you have withheld documents, and that on that basis, the document production statements are defective. When the starting point needs to be, are you saying that these document production statements are false? And so the most straightforward way forward is for the defendant's counsel.
Sorry to interrupt you. I'm sorry to interrupt you, but I've got a question. I think the defendants have made it quite plain that they do find the document production statements defective. They haven't done so aggressively, in my view, but I think they have in so many words mentioned on several occasions that you haven't complied with the order, you haven't complied with it properly. So to me, this sounds like it's just an extra step, and you're trying to buy time. But what effect does that process entail?
The practical effect is this: if this application proceeds to an oral hearing, we provide evidence, this application is likely going to fail, because the order sought would be ineffectual and futile, because the starting point is that the document production order requires verification through document production statements. The starting point is have honest and true document production statements been made. And there is a legal test for compliance, and it's not for me to say what that is, because as I said before, that reverses the burden of proof. And all we're asking is put us on a fair and equal footing. If you say we have not complied, and the alleged compliance, and again, I'm keen not to enter into the merits of the application itself, because that's not why we are here today. The merits of the application, the arguments all assume that documents have been withheld and the statements are false. So whereas in a hearing of this application, in a hearing of an application to compel compliance with the order, the starting point has to be the statements themselves. Is there a false statement that's been made? And we work back from there. We're not happy with the documents that have been produced, and we believe that other documents have been withheld. That is the wrong test.
What's the authority for this test?
Again, I'm mindful that it's for the defendants to state the test. But if you insist, it's talim.
How do you spell that, Mr. Krishna? Is this a case?
It's the talim case in this court. I can give you the reference, but as I said, I was not prepared to address the merits of the application at this hearing, but yes. I can definitely send it on. It is for the applicant, the defendant, to show that the talim test has not been met.
Mm-hmm. Okay, carry on, Mr. Krishna, and I'll raise my questions at the end.
So there are two fundamental issues here. One is there is a legal test for compliance with document production orders. That's not been addressed. Rather, it's this roundabout way of, we believe there are other documents that have been withheld, therefore your document production statements are false, which is wrong. The starting point has to be the document production statements themselves and how they have or have not addressed the order. Second, if the second aspect is this Dubai codes type application that give us the originals or we will not respond. Now, what has been produced in terms of Gmail correspondence and WhatsApp communications are searchable electronic documents. So to say that there is this mythical native format of WhatsApp, native format of Gmail, and you've not produced that, well, I'm entitled to say, what is this form? How is it reasonable to produce? You tell us that so we can respond. Rather, again, it's a reversal of the burden of proof for me to show that it's simply not possible to produce quote unquote native or original forms of those. Now, is the allegation that these documents that have been produced are false? Without that, I mean, we cannot start with this assumption that documents have been withheld. It's a complete reversal of the parties' respective burdens of proof, which is why we say this application is premature. These issues can be dealt with in correspondence, and the procedural timetable can be, the disruption to the procedural timetable can be minimized. We don't have to set it aside, deal with this at a hearing, and then eventually come back and try to resurrect the procedural timetable. And it is for this reason that in our skeleton argument, we've said, is it really appropriate for this to proceed as an application to compel compliance? Because if it is, our answer is straightforward. We have complied and we have verified compliance through these statements. And you have not addressed the applicable legal test to say that these documents are not compliant, or the document production statements are not compliant. And in respect of these so-called native format documents, why do we need native format documents as opposed to these electronically searchable documents? Therefore, rather than setting aside the procedural timetable and progressing to this application to a hearing, we say the more straightforward approach would be to iron out these issues in correspondence. If there's anything left outstanding after that, it can be addressed at the progress monitoring date. Because in respect of the documents that have been produced, those should be dealt with separately in terms of their relevance and materiality. No, this application cannot be used as a means of getting an evidential ruling on the documents. That's not the purpose of such an application. And we have in our skeleton shown you examples, including a case in which Curtis themselves were a party, they were the claimants, where if the specific format has been required of the parties, the case management order says so.
Mr. Krishna, my main issue with all of this is that the progress monitoring date, which at the moment is listed for the 16th of February, is about a month before trial. We are running, obviously, I know that the parties agree that there needs to be a readjustment of the procedural timetable, but the progress monitoring date is not really the time for the parties to sit down and nut out issues to do with document disclosure. This ought to have been done ages ago, and I would say that, right, and I would say that if there was such a thing as a requirement for a document production statement, then wouldn't that already be included in the CMC order? And it hasn't been. So I mean.
If I may,
Yes.
there are two orders here. There's a case management order and there's a document production order. The case management order says documents have to be produced by a certain date, and I agree that there have been issues which then led to an application, which then led to the document production order being issued. Now, the question presented in the application is whether or not the document production order has been complied with. And the document production order is very clear as to what constitutes compliance and how compliance must be verified. Now, if we and if the issue now is, well, I mean, if we now produce say further document verification or document production statements, we will still remain open to criticism that we have not complied because of this issue with the format in which they are to be produced. Now, if there was a disagreement, the rules clearly provide that if there's a disagreement as to the format in which they are to be provided, this should be sent to a judge for directions, and ideally should have been done prior to the case management conference. So the thing is, here we are. I accept that, you know, there will be an impact on the procedural timetable. Now, the question from as far as I see it is, what is more appropriate? Do we bend the procedural timetable and deal with this application at a hearing, or do we try to resolve these issues in correspondence? Because we've stated what our concerns are with the application, and once those are resolved, it may be that we may not even need a hearing of this application. We can seek to reinstate the procedural timetable as best as we can.
Mr. Krishna, I mean, look, you know, round of applause to you for giving this your best shot for your client. But I'm just still not convinced that this is anything but a delay tactic coming from the claimants. And I really do well and truly believe that if there was no counterclaim, that this thing would be running at speed. Things have been quite delayed, I think, because of this impending counterclaim that's hanging over their heads now. It's this document production statement, as you know, I've been in this office for some time now. I haven't really heard or seen these be exchanged on a regular basis. I haven't really seen them you know, always included in trials and in bundles. It's not something, obviously, I know that they're used from time to time, but it's simply I think what you're asking for is a formality to say that, you know, put your thoughts on paper and tell us how you feel about the documents that we haven't produced.
Absolutely not. I do apologize, but I disagree with that characterization, because the allegation is we are withholding documents. Now, that is a serious allegation. Now, it puts us in a bind, because how do we prove that we're not withholding documents? We've provided document production statements. The court is being asked to disregard those and being asked to determine whether documents have been withheld. Now, the only way we can say we have not withheld documents is to say, here's a document production statement.
I get that. For example, in the form of an affidavit to say that, you know, this is all we have and this is all we've got, really. Okay.
Which is why we say, look, if this proceeds to a hearing and an order is to be made, such an order would be ineffectual and futile. So we shouldn't be wasting the court's time with this application. The more straightforward approach here needs to be to deal with these issues in correspondence. We have said we have no further documents. So what are we going to prove at the hearing other than we have no further documents? You know, so it's a question of appropriateness and what is the more appropriate way forward in relation to this application, unless we proceed on the assumption that documents have been withheld and these document production statements are false.
I don't know, Ms. Hineidi, if you think there's an opportunity for the Defendant's Counsel to respond to some of the comments.
I think so. I think so, Thank you.
Thank you very much. Quite a lot has been said, so I don't want to jump about, but I think there may be 3 points I need to address. Probably starting with what was just said by Mr. Krishna, Claimant's Counsel, regarding the usefulness of this application proceeding. I think what has just been said, again, emphasizes why this application has to proceed, because very clearly Claimant's Counsel disagrees with every single aspect of our application and opposes it in full, and hence a resolution is clearly necessary. Claimant's Counsel seems to be focused on one of the minor points of the application, which is the issue of native and original files, and I'll come to that in a couple of moments. But I do want to emphasize that that is a small part of the application. The application relates primarily to all the documents that have not been produced at all in any format. So far, including at this hearing, Claimant's Counsel has completely ignored the numerous points where we've identified clear holes in disclosure. One of those being that not a single document has been disclosed between the claimants themselves, which is completely implausible. The disclosure breaches are so egregious that we have proven in our application various examples where we have identified documents that refer to other documents, where we've identified documents that have been produced without their attachments. All of this has been set out in significant correspondence between the parties before the application was made. None of it was addressed, or at least not sufficiently addressed. Now the Claimant's Counsel confirms that they do not have anything additional. So very clearly, we do need to proceed with the application. We need some form of affidavit or some form of additional evidential response from the claimants, because following that, the defendant will, of course, be taking the type of measures that the registrar pointed out. At this stage, the defendant has, in the application, alleged that various disclosures are insufficient, that are defective, and that the document production statements therefore appear to be non-compliant. We do consider that we have proven that on the facts. We do also remind the claimants that there is, of course, a opportunity for skeleton submissions before an application hearing proceeds, at which point the defendant will be pleading the relevant legal provisions. Those are not necessarily needed in the witness evidence that has been filed so far. I would also like to remind everyone that, of course, so far all we have is the application. We don't actually have any response to the application from the Claimants Council, besides various letters that have been filed in the course of the last week, which have consistently changed their position as to what the claimant actually considers to be the case. But I think the overall message is that undoubtedly there are pretty much all of the issues in the application are opposed. And therefore, I am surprised to hear that the Claimants Council now again goes to the initial position they've taken about 2 weeks ago when they came on board, when they said that the application could be potentially resolved in correspondence and by agreement. That seems to be now much further away than it was 2 weeks ago when we saw that a new council came on board, and we were in fact amenable to discussions, and we did say exactly that subject to whatever can be agreed, we can certainly amend the application or ensure that only issues that are not agreed are considered. But in fact, all of the issues are not agreed. And the claimant obviously has a position about the success of the application. We clearly disagree with that. We do think that we have a very good chance with the application in terms of the test, etc., that the claimant is suggesting that needs to be complied with. So that's the first point I wanted to make about the usefulness of this application. And I think the registrar already pointed out that the other aspect to this application is the time during which it is made, i.e. disclosure needs to complete before witness evidence. It cannot complete 1 month before the hearing. So the alternative proposal that claimant has made is simply unrealistic, because the disclosure, and as I say, the breaches are egregious. We've set them out in the application, but without some additional disclosure, the case shouldn't proceed. So if the claimants respond in their response to the application, as they now say in this hearing, that they have nothing else, without going into addressing any of the submissions we've made in our application and explaining the various inconsistencies that we've already identified, then of course the parties can consider the next steps and can consider the committal orders or whatever they may wish to make at that point. But that is why, again, the application needs to proceed now. Alternatively, of course, we do hope that the application will lead to in fact disclosure. And as the registrar hopefully noted, they are counterclaims, which is exactly why the defendant, rather than pursuing with immediate judgment or other types of processes, wishes that disclosure is in fact completed as ordered, so that the case can proceed to hearing on the basis of the documents that have been disclosed. So that's the second point. And the third point, very briefly, on the native and originals, because of course that is something that seems to be one of the main concerns for the Claimants Council. As I said, from the defendant's perspective, it's one of the minor issues. It is one of the examples which, in our opinion, shows that the disclosure is defective, because very clearly what has been produced to a large extent are sort of PDFs without any metadata. And I understand that there's now a dispute about what originals mean. In the defendant's position, there shouldn't be any dispute about this, because we had asked in our initial document production order for originals. We have asked for documents. RDC already says what the document is. We've got RDC 28.1 and RDC 28.2, which describe what a document means and specifically say that it includes metadata. And Justice Giles, of course, specifically ordered documents to be produced. So from our perspective, it is very clear that what has not been produced are documents with metadata. We are, of course, very happy to discuss with the Claimants Council what kind of format we would consider has metadata. But I think Claimants Council cannot reasonably stand up now and claim that they have complied with the order or the IDC, because the documents do not have metadata. They are copies that have been made in PDF that do not have any information about their original date. And that is exactly what happened, especially with the emails that have been PDF'd. So you don't have the attachments with them, which is why we've also asked for attachments, most of which have not been provided to date. So in our position, it is a small issue. It is an example of why the document production has been defective. It is certainly something that we'd be very happy to resolve with the claimants separately with the application if they wish to provide us an example of a document with metadata. I'm sure we will be able to agree that that's an original. All I can say at the moment is that originals have only been provided for some of the emails. So some of the emails are in original format with exhibits, attachments, whereas most of the emails are PDFs and most of the WhatsApps are simple PDFs. And you know, so it is clear that the production is not compliant. What an original means, we're happy to discuss that with the claimants. But what we are not happy about is this request for a judge to consider this one issue, which we think is entirely inefficient when we have much more significant issues to be considered as part of the application. So even if the claimant is right and there is some dispute about what originals mean, which we don't think is the case, but even in that case, it would be nonsensical to take this issue to a judge first before taking all the other issues, which are significantly more important from the defendant's perspective, to a judge on the application. The claimant started the submissions by saying that they want to limit the disruption to the timetable. That's exactly what we would like to do as well, but we do believe that at the moment the claimant is really doing exactly the opposite. They've asked for this directions hearing. They've now asked for an extra 2 weeks to respond to the application if the registrar considers that the application needs to proceed. Then they're asking for another hearing to decide only the issue of originals and on native format files, which is in our view not necessary. And at that point, we may be, a month or two from now and still without any resolution of the key issues in the disclosure application, which is basically the failure to disclose various documents which we've set out in our application have not been disclosed. We do require a response with evidence from the claimants on these issues, following which the defendant will then consider the next steps and will then consider whether to assert dishonesty. Just to be absolutely clear, we have not asserted dishonesty, nor do we need to assert dishonesty at this stage, because of course the application hasn't yet proceeded. But we certainly reserve our right to do so, because at the moment, as the registrar already noted, we have identified various issues with the disclosure that is not compliant. And hence, once the application proceeds and the next steps take place, there may well be allegations of dishonesty, but it is premature at this stage to make those allegations before the claimants have had a chance to respond. I apologize if this is a rather lengthy response, but I think these are the 3 points I wanted to raise, and I'm of course welcome to take any questions.
Thank you, Ms. Burt. Mr. Krishna, look, at the end of the day, I think what we're aiming for is to get matters moving as quickly as possible, so that there's not too much delay to the procedural timetable. I can sit here now, but the problem is, and the problem is I can't deal with the application at hand at the moment, Ms. Burt. And I don't think you want me to deal with the application at hand at the moment. And Mr. Krishna said himself that he wasn't prepared to argue the merits of the application. But I think that obviously if the defendants consider that there are a number of issues to be determined, they should be placed before the judge. Typically the judge would be the judge who is taking the trial in the case. Then I'm not going to prevent them from that opportunity. To make things move a little bit more efficiently, what we could do is, Mr. Krishna, I disagree with the comment that you made about the burden. I think the burden is entirely on the claimant in this scenario, and that's by virtue of the order of Justice Giles dated the 29th of September, where the order is essentially for the claimant, directing the claimant to do certain things. I think it was the order of the 29th. I could be wrong, but I believe it is. Yes.
It's the order dated the 31st of August.
31st of August. That's right.
It's at tab S1 if you want to.
Thank you very much, Mr. Krishna. Just bear with me. S1. Yeah, that's right. So as you can see from that order, it's directed to the claimant. And if the claimant is unable to comply with it, then the burden essentially rests on the claimant to say that we have complied with this to the best of our ability. This is why we think we have complied with it to the best of our ability. This is what we've done to carry out a reasonable search to locate documents in these relevant categories, and so be it. But I understand that no such statement has been provided by you. So obviously, I know what you're saying. You're saying, and I hear you, you've said on several occasions that no, the burden is on the defendants to say that these are the categories that have not been complied with. And you're saying that the burden is on the defendants to then provide their comments on compliance, and that would be the best way forward. But unfortunately, that's just going to prolong things. I think, in my view, my very strong view, I think that the burden is very much on the claimants. Now, I think that if you were to produce such a statement within 7 days from today, I think that would be very reasonable. And I think that the application should go to hearing, but I would probably encourage the defendants to amend the application, because I know that this is going to go to the judge, and the judge is going to say, hang on a second, you are asking me for an order compelling the other side to comply with my previous order. And that's not going to make him very happy. So I think that what the parties ought to do is probably have a discussion as to next steps, and the claimant provide, like I said, an affidavit in, say, the next 7 days, setting out the extent of compliance with the 31st of August order. And then the defendant then perhaps have a opportunity to respond to that if they so wish. And if that doesn't work out, then I think the defendant should amend the current application to include a provision for an unless order, as well as all the other relief it seeks in the current application, and then that go to hearing quite soon. I'm not going to suggest it goes to hearing in 4 weeks. I think it should go to hearing well before 4 weeks, because we're approaching the Christmas period and everyone's on holidays. So I suggest that that would go to hearing perhaps in 3 weeks' time, with skeletons to be exchanged about 4 days prior to the hearing. But I do think that this cannot wait until the progress monitoring date. That's not the forum for it. That's not the time for it. The progress monitoring date is simply a touch base with the parties, simply to see how things are going. Are you all well? Are you ready for the hearing? How are the logistics going to be set up? Typically what we would discuss is what witnesses will be called, where they're called from, how they'll be sworn in, how the swearing in will take place. These are the types of things that we discuss at the progress monitoring date. We don't do much else these days on the progress monitoring date. In fact, a lot of the time when things are going quite smoothly, we dispense with the progress monitoring hearing, and we also dispense with the pretrial review. But I think that in this particular case, we need to case manage it quite tightly, because there is no disagreement. Sorry, there is no agreement on much. So what do we think of 7 days, Mr. Krishna, for the claimant to simply set out the extent to which it complied with the 31st of August order, why it thinks it complied with it, on what basis, how it carried out a reasonable search to locate documents, and then if the defendant wants to respond, then it may do so. Yes, Mr. Krishna.
I'm much obliged for those for your indication of the potential directions and in relation to the progress of this application. I'm in your hands now. You've addressed the question that I had in mind, which is, in terms of paragraph 9 of the document production order, verified compliance through document production statements. Now, what else is required? If it is affidavit, if you are to provide affidavits from both claimants as to what steps they took to comply, over and beyond what's stated in the document production schedule and the document production statements, we should be able to do so within the next 7 days, because in any case, I mean, we had reached tentative agreement in relation to the exchange of, the provision of witness evidence in response. As you'll see at the foot of the unagreed list of issues, that from 2 weeks from 24th November, which effectively puts us at the same date. And that's fine with us. If affidavits are required, we will produce affidavits. And then, with the rest of the directions that you're minded to issue, I have no qualms with that.
Good. So, Ms. Nisbet, what do we think of this approach? So affidavits within 7 days from today's date, just to verify what's been produced, what they could not produce. That will pinpoint and give you a list of issues to discuss with the judge at the hearing, which will be scheduled in about 3 weeks' time. And then my second direction is that the claimants should, within also, I would say 7 days maximum, the defendants should perhaps consider amending the current application so as to make provision for an unless order in case one is required, so that we're not wasting further time. And that can happen within 7 days. The claimant can then respond to the application within a week from that date, so 2 weeks from today, and the hearing is then listed on the 3rd week, so 3 weeks from today's date. With skeletons, let's say 3 days before the hearing, skeletons should be exchanged. How do we feel about that kind of timetable?
Thank you very much, Ms. Hineidi. I do really appreciate your proposal to take this forward, and from our perspective, we really do not intend to delay the issue. We had initially agreed with the claimants that since they have asked for 4 weeks to respond, and because of the Christmas period, that we would get 2 weeks to respond to their response, and that the hearing in that case would then take place in January. I also will need to check the calendar of our counsel. I should say that Sophia Hurst, who signed the skeleton, is the counsel for the defendant that has made submissions in this application, but unfortunately she caught COVID over the weekend, which is why she couldn't make today's hearing. And I don't have her availability. I'm sure she'll be fine in 3 weeks' time, but I hope that the hearing can be scheduled then, and I'm also happy to progress the defendant's response faster than we had anticipated, and as Ms. Hineidi suggests, within a week rather than the 2 weeks that we asked for. But if that's okay, I will need to just double check with her, in terms of the setting of the date for the hearing. Hopefully that works. But otherwise, I think it's, of course, we're very happy to amend our application to include the unless order as directed. Thank you very much for that suggestion. We're also very happy with receiving the affidavits as suggested. I do hope that it's clear to the claimants they have a very lengthy application with several lengthy letters in which we have identified various issues, deficiencies of the disclosure. So I realize that the claimants' counsel is new on the record, and I hear during this hearing today that they have they considered that compliance was made simply by filing the production statements. But I do want to just remind the claimants that we have identified several issues with the disclosure. So from our perspective, and in order for the defendant to proceed with any next steps that may follow this application, we do want the claimants to address the issues that we've identified, address the various failings of the disclosure, which we say prove that the document production statements are non-compliant. So rather than simply saying, well, we've complied, I think the response from the claimant needs to be slightly more detailed and actually go to the merits of our application and the issues that we've identified. And the various examples we identified where clearly documents are missing, even on the basis of what has been provided. So I hope that that's something that can be done, and in that sense, I guess we agree with proceeding as quickly as possible with the application as suggested by the registrar. Thank you for that.
Thank you, Ms. Burt. I'm very much okay with the parties taking a bit more time if they need it. And obviously the onus is on the claimants to provide the statements and affidavits that they wish to make. I would strongly urge that they're as detailed as possible so that everything is fleshed out before this goes to hearing in a few weeks' time. But I'm going to ask the parties to prepare a draft order. If you want to extend the timelines, I'm very happy for you to do so, provided that they're agreed. If they're not agreed, please do let the court know. And we will, I will impose our timeline subject to the court's availability. So if the parties wish to, like I said, flesh out, for example, the timelines for the exchange or for the provision of the claimant's affidavits, I'm happy for those to be extended from, say, 7 days to 2 weeks if Mr. Krishna will struggle to provide them within time. In terms of the amendment of the application, Ms. Burt, again, I understand that Ms. Hurst is unwell at the moment. If you need 2 more weeks to do that, that's fine. Again, responding to the application, if you need 2 to 3 weeks, I think you either said 4 weeks, Ms. Burt, for all of the exchanges to take place. I'm also happy with that, with a then possible hearing in January. That is fine with me. But if you can't agree to it, I will be sticking to the timelines that I've just discussed, which is a week, with a hearing on the 3rd week. I don't think I'm in a position to make an order as to costs at the moment, so I think costs ought to be in the case. And is there anything else that's outstanding?
If I may, just one thing, and this is, this is not something that we want, but as things stand, unless this application is decided, I think it logically follows that the parties cannot exchange witness statements in relation to the merits of the case. So I wonder if any specific directions are required in respect of the procedural timetable at this stage, or if that can be revisited in the order of the judge at the time that this application is heard.
I mean, that was definitely my thought. I'd prefer that the parties now focus on the issue at hand, which is document production. And then focus on witness statements, because I think it'll be pretty much impossible to prepare witness statements with such a lack of documentation floating around. Ms. Burt, what are your thoughts on that?
No, thank you. We agree. I mean, as we've said in the application, and that's one of the key reasons for the application, we simply do not feel that the defendant can currently put in evidence until these egregious disclosure issues are handled. So we do consider that that timetable needs to be delayed until after the resolution of this disclosure issue. Of course, if the claimant's counsel identifies that some disclosure is still outstanding while it is reviewing the file, and I'm appreciative of the fact that claimant's counsel is new to the case, and if such disclosure is forthcoming, let's say when the affidavit is forthcoming in 1 or 2 weeks, whatever we agree, then of course we can again discuss with the claimant's counsel how to move the case faster. If for whatever, if for example some disclosure is forthcoming and we feel that we now have sufficient disclosure to progress with witness statements, then maybe we can discuss to have those run concurrently, or at least to start the deadlines for the remaining timetable sooner. But for the time being, we cannot agree to that. So for the time being, and until there's some further disclosure, we do consider that the timetable needs to be stopped.
Okay, very well. So I think we'll proceed on that basis, and perhaps that should be included as a provision in the order, in the draft order that the parties will prepare. And what I would like the parties to do, obviously, is to have a think about a new procedural timetable that they want to propose with new trial dates. But at the moment, I'm going to instruct the registry to vacate the trial in March, and we can stay the procedural timetable except for the document production process. And it's most likely going to be the case that the progress monitoring date is to be vacated, but I'm not going to vacate it just yet, just in case the judge wants a return date after the application hearing, which will proceed either in December or early Jan. So if the parties wouldn't mind preparing a draft order to the effect of what we've just discussed, if you would like me to repeat the points, I'm happy to. Otherwise, if you can get a draft order to the court, ideally by close of business today, that would be fantastic. just setting out the timelines that you both want to comply with for the claimant for the affidavits, and then the defendants for the amendment of the application, and then the response, claimant's response to the application, any evidence and reply that the defendants might have to the claimant's evidence, and then proposed hearing dates. Skeletons, like I said, would have to be submitted at least 3 working days before the hearing. And then again, costs are in the case. The procedural timetable be stayed, except for the document production process, which should be, it should continue insofar as the application is being completed, and insofar as the parties try their very best to amicably settle any document production issues that they might have. But in terms of witness statements and all other procedural deadlines, those will be stayed pending the new procedural order and timetable, which will be produced at the next hearing by Justice Giles.
Thank you, much obliged. I will prepare a draft order and send it across to Ms. Burt. And
Thank
we'll
you.
Thank you very
much
much from our side, and thank you. Thanks very much,
Mr. Krishna, and good to see Mr. Krishna on the case. His clients are in good hands, so thank you very much.
Thank you, thank you. I hope we can get this back on track.
Thank you, Mr. Krishna. Thank you, Ms. Burt. Have a lovely
Thank you very much, all.
Thank you.
Have a good day.